What if I told you there was a way to provide creditor protection for your beneficiaries and to protect your beneficiaries from their own bad choices? Additionally, what if I said you can do this without any special legalese in your trust, but done in plain English where it's clear what you want? Well, if that sounds interesting, then stick around as we discuss spendthrift provisions for your trust. But first, please be sure to like the video, subscribe, and ring the bell. Also leave a comment below if you have any questions or have a topic you wish for us to cover. But as always, thank you very much for watching. A spendthrift trust, or a trust with a spendthrift provision in it, is a trust which, by its terms, prevents a beneficiary's voluntary or involuntary transfer of trust assets and requires no special wording to establish, so long as your intent is clear as the settlor, or the one making the trust. I'll get into voluntary and involuntary in a minute, but generally speaking, this type of trust or provision makes it so that if someone is a beneficiary of a trust, their creditors cannot collect from the trust for that beneficiary's share of the trust estate to satisfy that beneficiary's debts. For example, a son is a beneficiary of his mom's trust with a spendthrift provision, and he has credit card debt going into collections. So long as money has not been distributed from the trust to the son, his creditors cannot look to the trust to satisfy the son's debts. Since there is a valid spendthrift provision, creditors are barred from reaching the beneficiary's interest in the trust unless or until the monies have been paid to the beneficiary from the trust. As you can imagine, this is a powerful tool to have your estate plan protect your beneficiaries, likely from themselves. However, there are some exceptions, but let's differentiate voluntary versus involuntary actions by the beneficiary before jumping into those. By voluntary transfer, we mean something done by the beneficiary themselves to cause the debt to be owed. Some examples include taking out a loan or agreeing to guarantee someone else's loan. By involuntary, we're referring to debts that are due for repayment due to a creditor's actions like filing a lien or getting a judgment from a court. In essence, debts the beneficiary either agreed to or debts to which they have become liable for whatever reason. As mentioned before, a spendthrift provision is not 100% bulletproof. There are 5 exceptions, the first of which is going to be the government, both federal and state, in order to settle debts to the government, such as unpaid taxes. The second is a spouse, or likely an ex-spouse, seeking spousal support. Third is where there is a child seeking child support. Fourth is fun though. It's an exception for someone who preserves the interest of a beneficiary, which for example would be an attorney. I wonder who wrote that exception into law. And the fifth exception is a bit of a catch-all, that being a provider of necessities. An example would be someone who provided something like food, shelter, clothing, and medical care. However, outside of emergency medical attention, it would likely take a lot to show that something provided to someone was such an important necessity as to allow the collecting against money the beneficiary cannot yet themselves access, like in a trust. A question that may have come to mind for you is that of your own interest in the property you put in your trust. If you can protect your beneficiaries from their own creditors, can you protect yourself from your own creditors? Unfortunately, or fortunately if you're a creditor, you as the owner cannot create a spendthrift trust for yourself, yet also retain an interest in the property and management of the assets in the trust. This is called a self-settled trust and is illegal unless you live in Alaska, Delaware, Hawaii, Michigan, Mississippi, Missouri, Nevada, or New Hampshire. You may have heard about self-settled trusts, but just called something different, an asset protection trust. In essence, this type of trust is one wherein you make the trust, you put your assets into the trust, you manage the trust as the trustee, and creditors can no longer reach your assets in the trust for a debt you personally owe, which would be different than a debt owed by the trust. The only way to do some type of asset protection in a state other than the ones I mentioned earlier would be to create a trust with a spendthrift provision in it, but lose the retained interest of the assets in the trust, such as putting a house in the trust, only retaining a right to occupy it and not being allowed to pull the asset out of the trust. There is one allowed way to do a self-settled trust in California, but it entails making the state itself the beneficiary, and that's a topic for its own video. Click here to learn about land trusts versus LLCs and when you should use one over the other, or watch this other video.